For judgment, item number 1.
The case is remanded back to the trial court for proper finding on issue 4, 5, 7, 8, 12, and 16. With the above findings and modifications, the appeals are disposed of. Right. The other pages, send it to me.
My pleasure, Lordship.
Yes.
Lordship, if I may kindly be allowed to move the unlisted criminal petition. Lordship, I filed it on Friday, on 27.
Tomorrow? Did it come up tomorrow?
Lordship,
Oh,
it's a
tomorrow is a
tomorrow.
holiday, yes, yes. What's the urgency?
There's an urgency in the matter, Lordship.
Okay, let's see. Let it-
Please, my lady, I beg to mention item number 5.
Yes.
Here the matter is before the screening committee for regularization. So I pray that 4 weeks time may be granted to us.
Okay, already put up.
Yes, put up to the screening committee.
Learned Counsel, Ms. Lee Shukri, appearing for the respondent's number.
For all the
For all the
respondents.
respondents, submits that the case of the petitioner has been put up before the screening committee for regularization, and accordingly prays that she may be given 4 weeks' time to receive further instructions. So, Learned Counsel for the petitioner, Ms. Such and such person, stop list after 4 weeks.
Much
Yes.
For motion, item number 3.
Yes,
My lord, I love the petition, taking parts for this case.
okay. Contempt,
Yes, ma'am.
which is the order? This court's order, page,
Is 35.
page 35. And what was the direction given?
Even if you dispose the case, this honorable court has passed this order on 26/5/2020, giving 90 days time to dispose the case, taking into cognizance of the survey report dated 9/9/2022. So despite that, ma'am, DC Dimapur has failed to comply within the 90 days, and he has started the proceedings after that. And the order was reserved on 17/12/2025. Until that, the order is not passed.
Not passed.
Yes.
No, page 35 is the correction. This was filed for correction, but the main order,
Page number 7, ma'am. Page number paragraph 14.
main order is this 2/12/21, isn't it?
Main
2/12.
order is 26/6/25.
Have you annexed?
Yeah, no, it is in the main petition. Page number 7.
Page 7.
Page number 14.
No, but this 26/6 order, have you annexed here? No. Without that, how will the court know? You have to annex it in your petition, because that is the main order, isn't it?
Exactly.
Whereas this other one, this IA, is only for correction of certain omissions. Whereas the main order is in 26/6/25, right? So, you'll have to annex that. Why don't you do something? You file an additional affidavit annexing that main order, okay? Learned petitioner appearing in person, Mr. What is your name?
Here, look.
Mr. Such and such, prays that he may be given 1 week, 1 week to file an additional affidavit to bring on record the judgment and order of this court, dated with para 7, to bring on record The judgment and order dated 26/6/2025 passed by this court in WPC
Yes, 213
to WPC in WPC
22.
213 of 2022. So, prayer is allowed. It's least after 1 week.
For admission, item number 4.
My ladyship, I am for the respondent number 2.
Yes. Mr. Sikopi. Yes, what happened? Affidavit in reply, you'd like to.
They have already filed.
Yes.
It's ready for hearing.
No, in COP, what hearing? Unless you have complied or not complied. That's the only thing.
Additional affidavit saying that the direction was in the WDC. The one operating duty was to consider the case to the petitioner for appointment on commissioner term within 2 weeks, 2 months. For non-compliance, the petitioner had filed contempt, the instant contempt. During the pendency of the contempt, we have come out with a list wherein the name of the petitioner was reflected at serial number 65. Being agreed, again the petitioner challenged that list and the addendum because the list was prepared as per the addendum of 2019. So that addendum as well as the unity list was challenged.
In another writ petition?
Yes. Because in that list, as per the OM, we have prepared the list. The name of the petitioner was figured at serial number 65. So being agreed, the petitioner said.
Then what happened in that other
And then in the
petition?
subsequent petition, the court, this honorable court has directed to come up with the unity list was set as unquashed, and then this honorable court held that the addendum should be read prospectively, not retrospectively, and then directed the respondent authorities to come up with a fresh list. A fresh list again. So now we have come up with a fresh
With a
list,
fresh
wherein the name of the petitioner is figured as serial number 52. So we have complied with the direction.
Okay. Then we'll list, because petitioner is also not there, we'll list it after a week. We'll dispose it at admission stage. Learned Counsel, Mr. N. Longkumar is present for respondent number 2, and none appears for the petitioner when the matter is called list after 1 week.
For admission, item number 6.
With this lordship. The respondent have filed affidavit in opposition and I received this morning. Lordship, in order to decide this contempt petition and dispose of this contempt petition, the records of the writ petition will be required. Because this honorable
Why?
has to examine the basis of issuing a direction to consider the case of the petitioner and one of the 24 vacancies available at that period of time, Lordship. Because in the writ petition, Lordship, the stand of the writ respondent was that the name of the petitioner is in serial number 7.
Serial number
Serial number 7. That stand was not accepted by the honorable court because of the fact that during the last 4 years, although more than 60 vacancies arose, no commissioner appointment was made, which action was found to be contrary to the scheme of commissioner appointment. Therefore, during the time of hearing, Lordship, on consideration of the fact that none of the commissioner appointment was made during that period, although available vacancies were there, issue direction to consider the case of the petitioner and one of the 24 available vacancies.
No, that is there in the order also,
Correct,
in the
Lordship.
judgment also.
And now, by
It
filing affidavit,
says on compassionate ground against one of the 24
Correct.
vacancies.
And now,
in the
by filing
statement which is
affidavit,
produced by the government advocate.
Lordship. However, Lordship, basing on the instruction that I received, we have filed our affidavit. I have filed affidavit on 26 March 2026.
Yes, Lordship.
Where in
Saying
the-
what?
Stating that the present petitioner is placed as serial number 5 in the waiting list. So will be considered as and when the vacancy arises.
no, Lordship. That-
No, here it clearly says against one of the 24 vacancies.
Yes.
And you have not filed any appeal against this. It clearly says on compassionate ground against one of the 24 vacancies. So where are these 24 vacancies?
Lordship, in fact, we have been maintaining the list of those who are claiming on compassionate ground, which is at page number 10, annexure B. So this is the list maintained as on July 2025. That was last year, page 10, annexure B. So above the petitioner, there are four incumbent, and the petitioner is placed as serial number 5.
That aspect was already considered by this court before the writ proceeding, Lordship.
So, Lordship, basing on the waiting list, that is maintained, Lordship.
No, when the writ petition was being considered, at that point of time also you were at serial number 5.
7, Lordship.
At serial number 7 at that point of time. Now, the petitioner is placed at serial number 5, maintained as on July 2025. So, will be
No,
considered
but
as
what
and
happened to these 24 vacancies then?
Yes, Lordship.
Because at that point of time, when it was taken up before the single bench, the government advocate produced a statement showing 24 vacancies. So out of that, how many vacancies were there for compassionate appointment?
It should be 50%, Lordship.
not exceeding 50%.
No, not exceeding 50%.
Minimum of 10, Lordship, 10 balls should be filled up by commission appointment. And now if this type of practice is allowed, Lordship, the petitioner will not get appointment even in coming 10 years, Lordship.
Lordship, usually what we do is we maintain the list, and basing on the list, Lordship, and basing on the vacancy arises, Lordship.
No, if they give an undertaking, if they can give an undertaking that as and when your turn comes, you will be appointed, that will serve the purpose. Because compassionate appointment, you cannot claim as a matter of right.
Lordship.
But then considering the conduct of the respondents, Lordship, during the last 6 years, although 60 vacancies arose in the department, none of the vacancies were given to the commission.
Can you give an undertaking to that effect?
Lordship,
That
Lordship,
you
Lordship.
you will appoint?
Lordship, on the next attainable day.
But then Lordship, may kindly make a query, what happened to the 24 vacancies?
Lordship, this
Unless
is
this
a
was
contempt
supervised,
contempt
Lordship.
proceedings,
In
and then,
contempt, we
they
just have to see, and even substantial compliance is also enough. So if they have considered your case and said that you are in serial number 5, because again, if you are appointed ahead of the other 4, then they will also have a grievance.
Lordship.
So 1 week,
2 weeks time, Lordship.
1 week, just to
Lordship.
get that undertaking.
Lordship, Lordship.
Learned counsel for the petitioner, Mr. Wati Jamir is present. Mr. V. Jimomi, appearing for the respondents, sole respondent, submits prays that he may be given a week's time to get further instruction. Yes, this after 1 week.
I beg your pardon, Lordship.
Yes.
Item number 4. I was on my leg,
You were absent.
leg in the court number 1.
What did I say in item?
Item number 4.
We have listed it after a week, I think.
After a week.
After a week.
Okay.
You record her presence also, learned counsel for the petitioner, Ms. Zimon. Yes.
Obliged, Lordship.
For admission, item number 7.
What is this? Continuation.
Lordship.
May it please your Lordship.
Yes.
Lordship, the IA 59 of 25 is for condonation of delay of 60 days. Lordship, I'm for the respondent number 1 to 3.
1 and 3.
1, 2,
1,
3.
2, and
1,
3.
2, and 3. Lordship.
What about the other respondents? 4 and 5.
Lordship, as per the office note dated 12/11/25, notice upon 4 and 5 delivered.
Delivered. Okay.
Lordship, delay may be confirmed subject to the deposit of the 50% of the award. We are yet to file objection to it.
Okay. Have you filed any stay application also?
No, Lordship.
No.
Lordship, it's due. IA 61 of 2014.
Let's see, IA 61. Oh, yes. Okay, we'll admit the petition then.
Lordship.
Admit the appeal. The instant application, this is IA 59, okay? The instant application has been filed under Section 5 of the Indian Limitation Act 1963, seeking continuation of delay of 60 days in preferring the accompanying MSc appeal number 7 of 2025. Stop. Learned counsel for the appellant, Mr. Such and Such is present. Stop. Learned counsel submits that the reasons for the delay in filing the appeal has been reflected at paragraphs. Which para? Paragraph 7.
7, Lordship.
Paragraph 7 of the application. Stop. The court has gone through the reasons for the delay which has been brought out in the application, and is satisfied that the sufficient cause has been shown for condoning the delay of 60 days in filing the connected writ appeal or connected MSc appeal. Accordingly, the delay is condoned. The petition stands disposed. Learned counsel, Mr. Intiwapang is present for the respondent number 1, 2, and 3. IA stands disposed. Then in IA 61 of 2025, you say the present application has been filed praying for staying of the operation of the impugned judgment and order dated 26/9/2024 passed by the MSCT Tuensang, Nagaland in MSc case number 1 of 2021. Stop. Learned counsel for the applicant, Mr. Such and Such, is present and submits that the applicant has filed an appeal against the impugned judgment and award 26/9/2024 passed in MSCT case number 1 of 2021 passed by the learned member Tuensang Nagaland, and the said appeal has been duly registered as MSc appeal number 7 of 2025. So, the learned counsel submits that the appellants have taken good grounds for appeal and are hopeful that and there is every likelihood that the appeal will succeed, and therefore it is prayed that the operation of the impugned judgment and award dated 26/9/2024 may be stayed during the pendency of the appeal in the interest of justice. So, the court has considered the submissions made by the learned counsel and has perused the records and is of the view that the impugned judgment and award dated 26/9/2024 passed in MSc case number 1 of 2021 passed by the learned member MSc Tuensang Nagaland may be suspended / stayed during the pendency of the MSc appeal number 7 of 2025, subject to the condition that the appellant shall deposit 50% of the awarded amount before the registry of this court within 30 days or 60 days. 30 will do. I think you'll need 60 days within 60 days from today. Yes.
Lordship, subject to the deposit, the appellant may be allowed to.
You file necessary IA after the
Lordship,
deposit.
Lordship, in the
Then-
meantime, DCR may be called for.
Yes,
Lordship.
let's see in the main appeal. Yeah, IA also disposed. IA 61 also stands disposed. Okay. Then in the main appeal 7, the instant MEC appeal under section 173 of the MV Act has been filed assailing the impugned judgment and award dated 26/9/2024 passed by the learned member MSCT Tuensang Nagaland in MSC case number 1 of 2021. Stop. Para. Heard learned counsel for the appellant, she is having such. Stop. Para. The main grounds taken by the appellant herein is that, what is your main ground? Is that the claimant respondent had not exhibited any cogent proof of income to prove the income of the deceased. So, the claimant had also failed to prove the fault of the offending driver of the insured vehicle by adducing evidence. By adducing proper evidence. Stop. Para. Admit the appeal. Call for the trial court records from the Motor Accident Tribunal Tuensang. List the matter after 4 weeks.
Obliged, Lord. Obliged, Lord.
For admission, item number 8.
May I please, Lordship?
1 minute. In the main appeal, MSC appeal, you reflect MT Wapang's name. MT Wapang appears for respondent number 1, 2, and 3. 1, 2, and 3. Yes.
My Lord, as directed by this honorable court, the IO has submitted the status
Yes,
report.
yes. Affidavit also? he
Yes,
got?
my Lord. Yes, my Lord.
Okay, we'll release it then.
Oh, my Lord.
The instant application under section 528 BNSS has been filed seeking a direction for release of the seized vehicle Mahindra Bolero bearing registration number capital AS-11T-1816 with chassis number such and such, engine number such and such. You just see from para 1, okay, the petition, which has been seized in connection with special case number 21/2025 arising out of narcotic cell PS case number 10/2025 under section 21C of the NDPS Act, read with section 3 clause 5/61 clause 1 clause small a /111 clause 2 clause B BNS. Stop. Third learned counsel for the petitioner, Mr. B. Soto, as well as Mr. Thipa Pom, learned public prosecutor. Stop. Para. The case of the petitioner is that his Mahindra Bolero bearing registration number such and such was when was it seized?
17/8/25,
Seized
my lord.
on 17/8/2025 by the personnel of narcotic PS cell Kohima. So it is stated that nothing was recovered from the seized Mahindra Bolero. Stop. It is stated that the petitioner is not involved in the instant case and is also not arraigned as an accused in the instant case. Stop. Para. It is submitted that the petitioner is the lawful owner of the seized vehicle, which was purchased from one Mr. Jayanta Kalita through a genuine car dealer, namely J.J. capital J.J. Highway Motors, by executing a valid sale transaction. Stop. It is further submitted that after the purchase of the said vehicle and upon obtaining all the necessary documents, the petitioner had also obtained the no objection certificate from the Transport Department, Kachar, Government of Assam. So, however, before the vehicle was registered in his name, the same has been seized and is in police custody since 17/8/2025. So, learned counsel for the petitioner submits that if the vehicle is kept in the open in police custody any longer, it will cause severe financial hardship to the petitioner, and the vehicle will also be exposed to natural deterioration, loss of value, and mechanical damage. Stop. Para. You have prayed before the Tri-Court also, na?
Yes, my lord.
Which order was that? 4-2.
4-2, my lord. Yes, 4-2.
It is further submitted by the learned counsel for the petitioner that a previous Zima application was also filed before the special judge NTPS, but the same was dismissed by an order dated 4/2/2026. Stop. Being aggrieved, the petitioner has approached this court. Stop. Para. Learned public prosecutor Mr. Tipapom was instructed to contact the IO of the case and to get necessary instructions as to whether the sale of the vehicle to the petitioner is genuine and legal. Stop. The learned public prosecutor has produced a report from the IO of the case and also an affidavit of declaration executed by the proprietor, by Mr. Jubair Ahmed, Jubair, Jubair Ahmed, 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 proprietor of JJ Highway Motors, dated 13 March 2026. Stop. The public prosecutor has also produced the updated case diary, and specifically on 18/3/2026, the IO has indicated that Mr. Jubair Ahmed, the proprietor of JJ Motors, has appeared before the IO and has produced the self-declaration in affidavit countersigned by the notary, Government of Assam. So, para. This court has considered the submissions of the petitioner and also perused the case diary as well as the affidavit of declaration. Stop. The proprietor of JJ Highway Motors has specifically declared that he had sold the vehicle bearing registration number AS-11T-1816, Mahindra Bolero to Mr. VIHRII PANIL, Viri Panel / petitioner.
It should be PANII.
N-I-I, okay. VIHRII PANII. Okay. By executing a sale deed dated 21/6/2025. Stop. The affidavit also declares that the sale deed executed between JJ Highway Motors and the petitioner on 21/6/2025 is legal, valid and genuine. Stop. The proprietor has also further declared that the vehicle was earlier owned by Mr. Jayanta Kalita, Jayanta, Jayanta Kalita, and the same had been sold to the petitioner hearing. The court is satisfied that the sale and purchase made between the petitioner and the previous owner, i.e. Jayanta Kalita, is genuine and valid. And accordingly, this petition is allowed, the petitioner shall abide by the following conditions. Number 1, execution of a Zima bond for rupees 50,000, for 30,000, for rupees 30,000 to the satisfaction of the investigation officer. Stop. The petition. Number 2, the petitioner shall not make any changes to the appearance of the vehicle. Stop. Number 3, the petitioner shall not sell or dispose of the vehicle during the pendency of the case. Last, the petitioner shall produce the seized vehicle if and when required by the court or by the investigating agency. Petition stands dismissed.
Much obliged. Well, in connection with this criminal appeal, as per the LCR, as per the case record, the LCR has been received. So, for the convenience of the court at the time of the hearing, and for the parties, paperwork may be
paperwork
directed
is
to be
necessary,
yes. So, as in when the paperwork is over, the matter may be listed for hearing.
This is that old case which was restored.
Yes, my lord.
Acha, so you are for the appellant?
Yes, my lord.
And
I am for the respondents. 3.
respondent 3, okay.
Yes.
And you are for respondent 1.
And for
And
R3,
what about PP Paul Hukavi?
I'm for respondent number 1. PP.
Okay. Okay. Learned counsel for the appellant, Mr. Pedangopang is present. So learned counsel, Mr. Azo is present for respondent number 3. And Mr. Chupa Nangkong for respondent number 1. Stop.
Otherwise, also repeatedly on 7 occasions,
How will we hear the petition without serving a copy?
on 7 occasions, they remain absent, Lordship. The last order is also not here, Lordship.
Lordship, kindly give the last opportunity, Lordship, the file service.
Lordship, the last order is also very,
See the order dated 6/11/25, then 24/11/25.
Lordship,
Nine-
kindly give some time, Lordship.
What happened?
Service.
You don't have a local council here.
No, Lordship.
You should keep one so that
Yes, Lordship.
such copies are served without delay.
Lordship,
Yes, Lordship. Kindly give some time, Lordship.
Three opportunities have been given to you.
Lordship, kindly last opportunity given, Lordship, the service.
Lordship, otherwise
And
also
without
the,
serving, you're trying to argue your case.
Lordship, the
Yes.
appeal was filed on 28/2/2025, Lordship. And then today they are appearing. Last consecutive on 7
Yes, yes.
occasions, they remain absent.
3 occasions they didn't appear.
No, Lordship, on 9/12/25, Advocate Vikramjit, he wrongly appeared. That day also they were absent,
Okay,
Lordship.
okay, okay.
Lordship.
Actually, he was not there
Me,
in the
Lordship.
case.
1, 2, 3, 4, 5.
Lordship, kindly last opportunity given, Lordship.
I think you're not being diligent in pursuing your case.
Lordship. Matter may be dismissed, Lordship.
Why shouldn't we dismiss it?
Lordship, kindly give some time, Lordship. 1 week, Lordship, 1 week time, Lordship.
And you're not appearing also when the case is being listed. One thing is you're not supplying the copies. Secondly, you're not appearing. See the last order 23.
Yes, Lordship. I'm appearing on behalf of F. Kapoti, Lordship.
Learned counsel,
There is some difficulty, Lordship.
learned counsel for the applicant, Miss Such and Such is present. Stop. Mr. Imti Wapang is present for the respondents number 1, 2, and 3.
Lordship.
This order, this court, by order dated 6/11/2025, 24/11/2025, and 9/12/2025, had directed the applicants to supply a copy of the application of the present application, as well as the appeal memo also not served, as well as the application in IA 18 of 2025 upon the counsel for the respondents. However, till date, the same has not been served. Stop. The applicant has also not been appearing on several occasions when this matter was listed. Stop. As a last opportunity, the applicant is given, how much time?
1 week, Lordship.
Lordship,
week.
within the course of the day, Lordship, the appeal filed last year on February, Lordship.
You give it today itself?
Today is not possible, Lordship. And 1 week time, Lordship.
In 3 days,
Obliged.
to serve copies of the IAs on the learned counsel for the respondent 1, 2, and 3 within 3 working days from today. So list after a week. Yes.
Obliged, Lordship.
Obliged.
That publication. Learned counsel for the applicant, Miss Kim Penyu is present. Stop. On 6/3/2026, this court had allowed the applicant to take steps for service on respondent number 2 and 3 by substituted summons through publication. Stop. Learned counsel submits that she has not been able to take the steps till date, and therefore prays for another 3 weeks time to take steps on service on respondent number 2 and 3. So this after 3 weeks. Yes.
May I please, my lord? Lordship, this contempt petition is filed for non-compliance of the Honorable Court order dated 29/4/2025, passed in WPC 13 of 2025, Your Lordship, wherein this Honorable Court has directed the state respondent to regularize the work charge service of the petitioner, Your Lordship. Now, Your Lordship, pursuant to a cabinet approval, by a notification dated 24th of March 2026, the work charge service of the petitioners has been regularized. And therefore, Your Lordship, the
Regularized?
Yes, Your Lordship, the order has already been complied. If I may be allowed to place the notifications on record, Your Lordship.
You've got a copy? So we'll close it. Where's his name?
Your Lordship, on the last page, notifications dated 24th of March 2026, Your Lordship.
Learned counsel for the petitioner, Ms. Grace I. Namki is present. Stop. Learned counsel, Mr. N. Nangami, appearing for respondents.
For
one
all the
and
respondents, my lord.
For all the respondents, has produced a copy of the notification dated 24th March 2026, by which the service of the petitioner has been regularized. Stop. Accordingly, it is prayed that the matter may be closed as the order of this, as the direction of this court in
WPC
WPC
13th of 2025.
30 of 2025 has already been, no, you say as the order dated 29 for, as the direction of this court in the order dated 29/4/2025 in WPC 13 of 2025 has already been complied with by the respondents. So, the court has produced the order dated 24th March 2026, and accordingly it is found that the order direction of this court has been complied with. Accordingly, the matter is closed and disposed of. The order dated 24th March 2026 is kept on record and marked as document Y. Okay. Yes.
I'm deeply obliged, my lord.
For item number 13. May I please the Lordship? Lordship, the instant IA has been filed, Lordship, to vacate the operation of the Honorable Court's order dated 26/9/2025, passing criminal number 34/2025, which is at page 21, Lordship. 21. Order dated Annexure 6. The operative portion is at page 22, para 4. In the interim, the investigation process in the Dikupa PS case number 441/2024 under section 3162/341 IPC shall remain state till the next returnable date, Lordship. Lordship, we are agreed by this interim order, Lordship. Lordship, may kindly come to the page 3, Lordship, the operative.
Page 3, yes.
Page 2, paragraph 3, Lordship. If I'm allowed to read the paragraph 3, Lordship. The instant application has been filed seeking to vacate the Honorable Court's order dated 26/9/2025, passed in criminal petition number 34/2025. The brief of the case is that this Honorable Court, by an order dated 9/4/2025 in anticipatory bail number 10/2025, had granted pre-arrest bail to the accused respondent in connection with Dipupar PS case number 41/2024 under section 316(2/3184 of BNS Act 2023 on the following conditions. 1. The applicant is directed to appear before the investigation officer on 22/4/2025 for interrogation as well as for recording his statement, and thereafter as and when required. 2. The applicant shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade them from disclosing such facts to the court or to any police officer. It is also pertinent to mention herein that in spite of the Honorable Court's order dated 9/4/2025, the accused Mr. Ananta Barwa failed to appear before the IO of the case. Subsequently, on 2/5/2025, the Honorable Court accorded one last opportunity to the accused to appear before the investigating officer within 10 days, starting from the date of passing of the order. That too he did not appear. Thus, when the matter was again listed on 27/8/2025,
the interim bail was extended to the accused to appear before the IO through electronic mode video conference. If necessary, the IO on 4/9/2025 through video conference contacted the accused, but since he was traveling inside the vehicle, proper investigation could not be conducted. Furthermore, the Honorable Court by an order dated 11/9/2025 directed the IO investigating officer to provide security and record statement and thereafter to execute the bail bond as directed by the Honorable Court. As directed by the Honorable Court by an order dated 11/9/2025, on 18/9/2025, the IO and 7 armed personnel, along with 3 UBC, that is unarmed police constable, went to Sonali Pathar, Assam to pick the accused. However, upon reaching his residence, he was found to be absent. Therefore, in the presence of Chungjiang OC and Assam police personnel, IO personally called the accused over the phone and requested to accompany the IO and the team as directed by the Honorable Court. More so, adequate security arrangement has been provided to the accused. In spite of the repeated requests, the accused failed to comply, saying that he is in Dibrugarh. But it is found out or can be seen from his current location through LBS, that is location-based service device, that the accused was in Karbi Anglong. Be that as it may, when the anticipatory bail 10/2025 matter came up on 22/9/2025, the accused petitioner prayed to withdrawal. Accordingly, the Honorable Court has disposed of the application as withdrawn. Thereafter, the accused petitioner, after the withdrawal of the anticipatory bail 10/2025, filed a criminal petition numbered as criminal petition number 34/2025, prayed before the Honorable Court for quashing and setting aside the FIR dated 21/9/2024 and the investigation of the Dibrugarh PS case number 41/2024. The Honorable Court by an order dated 26/9/2025 has directed the state respondent not to initiate, we are agreed by this order, 26/9/2025 has directed the state respondent not to initiate the investigation process in Dibrugarh PS case number 41/2024, which shall remain suspended till the next returnable date. Therefore, it is prayed before the Honorable Court that the order dated 26/9/2025 directing the concerned investigating officer to hold the investigation be dispensed with, as the presence of Mr. Ananta Barwa to custodial interrogation is immensely required by the investigating agency to ascertain the facts and to ensure fair and just investigation. Moreover, the deponent reiterated to the statement that the Honorable Court by an order dated 22/9/2025 has disposed of the petition number as anticipatory bail 10/2025 Ananta Barwa versus the State of Nagaland, inter alia stating that all the interim order passed earlier shall stand vacated upon withdrawal. Petition is disposed of as withdrawn. Therefore, the accused petitioner withdraws the petition. However, no liberty was granted whatsoever. The deponent therefore submits that when the accused petitioner has withdrawn the anticipatory bail petition, the filing of the criminal petition number has 34/2025 tantamount to abuse of process, finality, and estoppel. Furthermore, a litigant who withdraws a petition, very important, Lordship. Furthermore, a litigant who withdraws a petition without liberty cannot be permitted to re-agitate the same issue by filing another petition under a different guise. Therefore, the present criminal petition is liable to be dismissed at the threshold, as the present petition is not maintainable, Lordship. Lordship, earlier they have approached this Honorable Court by filing an anticipatory bail, Lordship. And
when this criminal petition was filed, these facts were not brought to the notice of the court.
in fact, earlier they, no, Lordship. Earlier they have filed in the anticipatory bail, Lordship. And Lordship, from the anticipatory bail, Lordship, protection was given on several occasions by the Honorable Court, Lordship.
This criminal petition, when this criminal petition was filed, the anticipatory bail application was already withdrawn, isn't it?
Already withdrawn,
Already
Lordship.
withdrawn.
After the withdrawal of the anticipatory bail, Lordship, they have filed this criminal petition for quashing of the FIR.
No, that's why I'm saying,
Lordship.
when this criminal petition was filed, when it was moved, all these objections were not raised by the PP, that he was not appearing, he was not cooperating.
No,
And all that.
Lordship.
Huh.
Lordship, since on that, since we were not, I was not aware, Lordship. Since anticipatory bail, the government counsel who appeared was one of my colleague, Lordship,
Okay,
for
okay.
which I'm not aware.
Different,
Different counsel, Lordship. And in the criminal petition, only while filing this criminal petition, we were aware that they are filing.
Yes, who's appearing? Oh, okay, okay. Yes.
Your Lordship, kindly go to your Honorable Court order dated 26/3/2026, Lordship. Honorable Court order, Lordship. So may I please to read Honorable Court order 26/3/2026. Learned Counsel, Mr. So-and-so. The learned counsel for the petitioner submit that we have first copy of the petition on the respondent number 2. Complained by State Police for the Dipupar Police Station, Dipupar, Nagaland. A copy of the receipt of the State Post has also been enclosed in the complaint affidavit, which has been filed by the petitioner on so-and-so. However, it needs to be ascertained as to whether the concerned police station has served the copy of the respondent number 2. The learned CP, Mr. So-and-so, is directed to ascertain the same from the OC, Dipupar Police Station, Dipupar. Reach the matter forwarded. Now, the learned PP has a bounden duty to inform the court before the whether notice has been served upon respondent number 3, Your Lordship. But, however, the IA has been filed by the PP, but in such IA, Your Lordship, respondent number 3, who is the victim person on basis of their affair, so he was not impleaded as a party respondent number 3. So this petition is not maintainable at this stage, Lordship.
No, but it appears that you are not cooperating with the investigating agency.
Your Lordship, that is absolutely right, Lordship. Due to such and such reason, Lordship, due to the underground Lordship extremist fear of attack, Lordship, I did not appear before the concerned police station. I have already intimated before the authority at a relevant point of time when I moved bail application before this honorable court. But subsequent stage, I have withdrawn my bail application, Your Lordship. Then thereafter, Lordship, I have filed one another application with another issue, Lordship. So as per the BNSS Act, Your Lordship, 528, my application has been filed under the provision of
Just modify
528.
the order dated 26/9/25. We will say that the investigation will proceed, but
Lordship,
no
Lordship.
coercive steps may be taken.
Lordship,
Okay.
Lordship, Lordship. Lordship.
Yes. Heard learned public prosecutor, Mr. Rizi Momi, for the applicants. Stuff. Also heard Mr. Your name?
I'm sorry, yeah.
Saikia, hearing for the respondent/petitioner. Stop. Para. The instant application has been filed by the learned public prosecutor praying for vacating the operation of this court's order dated 26/9/2025, passed in the accompanying criminal petition number 34 of 2025. Stop. Para. The case of the applicant slash state of Nagaland herein is that the petitioner had earlier approached this court by filing an anticipatory bail petition number 10 of 2025, wherein this court by order dated 9/4/2025 had granted interim pre-arrest bail to the had granted pre-arrest bail to the accused / petitioner in connection with the Pupar PS case number 41/2024, under section 316 clause 2 / 318 clause 4 of the BNS on the following conditions. Number 1, that the applicant shall appear before the investigating officer on 22/4/2025, 22/4/2025, stop. In spite of this court's order dated 9/4/2025, the petitioner failed to appear before the IO of the case. Stop. Subsequently, on 2/5/2025, this court accorded another last opportunity to the petitioner to appear before the IO within 10 days, starting from the date of passing of the order. Stop. However, the petitioner failed to appear even after that. Stop. When the matter was again listed on 27/8/2025, the interim bail was extended to the accused, to the petitioner to appear before the IO through electronic mode. Stop. The IO on 4/9/2025 tried to contact the petitioner through video conference, but since the petitioner was traveling in a vehicle, proper investigation and recording of statement could not be conducted. Stop. Further, this court, by another order dated 11/9/2025, directed the IO to provide security and to record the statement of the petitioner, and also to execute the bail bond as directed by this court. Stop. Para. On 18/9/2025, the IO of the case, along with 7 armed personnel and 3 unarmed police personnel, went to Sunali Pathar, SUNALI Sunali Pathar, Assam. That is his residence.
Lordship.
Sunali Pathar, Assam, where the petitioner resides, to pick up the petitioner. Stop. However, upon reaching his residence, he was found to be absent. Stop. Therefore, in presence of Chungajan OC, CHUNGAJAN, Chungajan OC, and the Assam police personnel, the IO personally called the petitioner over the phone and requested him to accompany the IO and the team as directed by this court, and told him that adequate security arrangement has been made. Stop. In spite of repeated requests, the petitioner failed to comply, saying that he is in Dibrugarh, whereas it could be seen from his current location through location-based service device, under bracket LBS, close bracket, device, that the petitioner was in Karbi Anglong itself. Stop. When the anticipatory bail 10/2025 came up, was listed on 22/9/2025, the petitioner prayed for withdrawal, and accordingly the court has disposed of the application as withdrawn, and all the interim orders passed earlier were also vacated upon withdrawal. Stop. Para. Thereafter, the petitioner filed the instant criminal petition number 34/2025, praying for quashing and setting aside the FIR dated 21/7/2024 and the investigation of the Tipupar PS case number 41/2024. Stop. By the interim order dated 26/9/2025, the state respondents were directed not to initiate the investigation process in the Tipupar PS case number 41/2024, and a direction was given that the investigation shall remain suspended till the next returnable date. Stop. And thereafter, on subsequent dates of listing, the interim order has been extended from time to time till date. Stop. Learned public prosecutor submits that the petitioner has not been cooperating with the investigation even from the time when the anticipatory bail application 10/2025 was filed before this court, and therefore it is prayed that the investigation should be allowed to continue in order to ascertain the facts and to ensure a fair and just investigation and to arrive at a logical conclusion. Stop. Para. This court has. Acha, what is your submission, Learned Counsel? Mr. Sakya?
Your Ladyship, my submission is that the previous honorable court order dated 26 to 3 2026 directed the learned public prosecutor to ascertain whether notice has been served to the respondent number 3.
No, that notice is a different issue. That is notice on respondent 2. But regarding the prayer in the IA, they are praying for vacating the interim order.
Yes, Your Ladyship. In this case, Ladyship, that we have filed the interlocutory application wherein not included the party respondent number 3 in this present proceeding. So his statement may be required because this case is purely in a civil nature without getting any.
That is all agitated in your petition, that it is a civil case, there is no criminal ingredient, that you have already stated, but we are now on the IA. Their prayer is specifically to vacate the interim order suspending the investigation. So what is your submission on that?
So my submission is that this case may can be fixed for hearing stage. At this stage, only he filed the present IA. So in this present IA, the party respondent number 3 has not impleaded here. So his statement may be required. So previous honorable court order directed the public prosecutor to serve the notice. So now he is a duty.
You seem to be habitual offender. You seem to be a habitual offender. You are not cooperating at all. So you cooperate with the investigation and will give a direction not to take any coercive steps. Okay?
Your Ladyship, in my original criminal petition in para number 9, I have already mentioned in para number 9. In para number 9, that I have filed AB and subsequent stage same has been withdrawn. Even in my criminal petition, I have categorically mentioned. In annexer is page number 48.
See, this court even allowed you to to go before the IO with security, and they even provided the security, but the petitioner did not go. He was absconding. Even then, he was refusing to come with them. Acha, what did I say? The learned counsel for the petitioner, Mr. Mittu Sakya, praised that the instant application may be dismissed and that the main petition may be heard on merits at an early date. Stop. This court has considered the submission of the learned counsel for the parties and is of the view that the petitioner has not been cooperating with the investigation, and moreover, the notice on respondent number 2 is still yet to be effected, is still yet to be served. Stop. Accordingly, in the interest of justice, the interim order passed on 26/9/2025 is modified to the extent that the investigation process in the Tipupar PS case number 41/2024 shall continue and however no course against the petitioner. Stop.
Your Ladyship, may I please to interfere, Your Ladyship? Hello.
Some protection has been given.
My Ladyship, due to only for
And what about
fear of extremist attack, I did not appear before the investigation officer. That is my final submission. I have
you go and meet the IO?
before this honorable court. So finally, yes, this case may be fixed for final hearing.
Yes, we'll hear you. But you also approach the investigating agency. Yes.
For orders, item numbers 14 to 16.
Yes.
May it please, my lord.
Yes.
As directed by this honorable court's order, dated 2011-2025, I filed my IA for impleadment of Marangkong Village Council.
The instant application under Order 1, Rule 3, read with Rule 10, Clause 2, and Section 151 of the CPC has been filed by the state respondents, isn't it? By the state respondents, praying for impleadment of the Marangkong Village Council, Marangkong Village, Mokokchung,
As
respondent number
11.
11 in the instant petition. Stop. Third learned additional advocate general Mr. L.T. Sanktam for the applicant, as well as Mr. Moa Jamir for the respondent's number. For the petitioner respondents.
Lordship. Yeah, please, Lordship.
Yes.
I'm appearing on behalf of my senior Apila Sanktam. If my presence could be reflected.
For, as well as Mr. Such and Such for respondent number.
Respondent number in item number 16 for respondent number 10, and then for item number 15, respondent number 9.
No, but in the IA you will be. Okay, this KKB projects, KKB projects, and respondent number 10. Mr. Such and Such appearing for the respondent number 10. Stop. The applicant in the instant application submits that when the WPC 321 of 2023 came up on 2011-2025, this court had allowed the learned additional advocate general Nagaland to make an application to file an application for impleadment of the Marangkong Village Council. Stop. The learned additional advocate general submits that the land of the petitioner is within the village area of Marangkong Village. Stop. Further, the Marangkong Village Council has made an undertaking to the state respondents that no compensation will be claimed by any villager, and moreover, the petitioner being from the Marangkong village.
Yes, ma'am.
The petitioner being from the Marangkong village had also supported the undertaking given by the Marangkong Village Council. Stop. And that the petitioner could not turn around and take a stand that compensation should be paid in terms of the Land Acquisition Act of 1894. Stop. Therefore, learned additional advocate general submits that the Marangkong Village Council needs to be impleted as a necessary party in the connected writ petition number 321 of 2023.
And 236.
321 of 2023 and 236 of 2023. Stop. Accordingly, the prayer in this application is for impleadment of the Marangkong Village Council as respondent number 11. Stop. The court has considered the prayer made in the instant application and has produced the pleadings. Stop. it is seen that the Marangkung Village Council needs to be implemented as a necessary party in order to adjudicate the issues in WPC 236 of 23 and WPC 321 of 2023.
236, ma'am.
236 of 2023 and 321 of 2023. So accordingly, the instant application is allowed. So the petitioner slash the applicant slash state respondent shall file the amended cause title within a week's time, and thereafter take steps for notice. Steps also have to be taken, isn't it? No, that you'll have to do. Yes. Shall file the amended cause title within a week, and thereafter the petitioner shall take steps for service on the newly implemented respondent number 11.
11 will be in 331 and
11 and 3 in 321-23 and 10 in WPC 236 of 2023.
much of
I make a motion. Item number
18.
Yes.
Registered as file number on the session case number 45 of 2025 and section 316 of clause 2, 316 of clause 2 BNS. Which they have registered on 38 2025.
Let's see the FIR complaint.
Section 7 page 31.
Yes, yes.
To the officer in charge, North Police Station, Kohima, Nagaland. FIR against SAS Connect Private Limited for breach of contract. With respect and in reference to the subject, I would like to highlight that my firm, Eurotech and CESCO JD, has been awarded the work, namely construction of medical college at Kohima, now known as NIMS Kohima, Nagaland. And in regard to that work, we have given specialized subcontract to one firm, SAS Connect Private Limited, with person in charge, Public Managing Director, Mr. Binanda Boro, the principal business partner for design, execution, and commissioning of 142 kilowatt solar power plant, having their address at 80 Road, Ward number 5, near Masjid, North Jalukbari, Kamrup Metropolitan, Gauhati, so and so. In connection to this matter, as per the quotation terms given by Mr. Binanda Baro of SUS Connect Private Limited, they were supposed to design, execute, and commission 142 kilowatt plant for the main academic block power requirements, and basing on that, we have paid advance of rupees 10 lakhs on 20 January 2025 through Axis Bank Kohima, and subsequently rupees 40 lakhs on 4 February 2025 through Bandhan Bank Kohima, totaling an advance amount of rupees 50 lakhs. However, the mentioned person in charge, Mr. Binanda Baro of SAS Connect Private Limited, has supplied only some components, that is solar panel, amounting to approximately rupees 29 lakhs only, leaving a shortfall of rupees 21 lakhs. Since then, the said person is not answering our calls, messages, or emails. Our firm has attempted and tried to contact the said person and company contacts numerous times, but failed to establish the contact. It is already 4 months now since we have paid the advance to Mr. Binanda Baro of SAS Connect Private Limited, yet they are not willing to give us any explanation on the delay of supply, nor they are showing any interest to complete the work or contact us. Therefore, considering all these issues, our firm has issued a legal notice to SAS Connect Private Limited to comply and fulfill the contract term within 20 days since the issue date of legal notice, but found out that their office is shifted or vacated.
Therefore, with the matters as stated, it is assumed and concluded that Mr. Binanda Barrow of SAS Connect Private Limited has cheated us and they have disappeared after scamming us, resulting in breach of contract with Urotech and Seskelano JV for design, supply, and commissioning of 142 kilowatt power plant. In regard to this matter, I am filing this FIR, and I humbly request your esteemed office to kindly pursue the matter and take immediate action against Mr. Binanda Barrow of SAS Connect Private Limited of so-and-so, Assam. Thank you, and I remain obliged to you.
So what is your ground?
Your Lordship, the plain reading of this complaint has nowhere stated that I am involved in the criminal activities as alleged under section 316 subclause 2 and 318 subclause 2. He has nowhere mentioned that I have cheated or has absconded after cheating him. The FIR, the subject of the FIR itself says that it is for breach of contract. Your Lordship, if you may kindly come to Annexure 4, page 23.
What is 316 BNS? Just give me BNS.
Breach of criminal trust. Lordship, 316 is breach, criminal breach of trust.
Okay, and 318?
318 is cheating.
Okay. Oh. Earlier 420 is now 318.
Yes, Your Lordship.
Criminal breach of trust and cheating. Okay. The present application under section 528 of the BNSS has been filed, praying for quashing and setting aside of the FIR filed against the petitioner on 14/5/2025 before the Kohima North PS case, before the Kohima North Police Station. Stop. The same has been registered as Kohima North PS case number 0045/2025 under section 316 clause 2/318 clause 2 of the BNS. Stop. Heard learned counsel for the petitioner, Mr. M. Kongyak, no?
Manjong Konyak.
Manjong Kongyak. Stop. Learned counsel submits that in the FIR dated 14/5/2025, it has only been stated that there has been a criminal breach of contract by the
Lordship, it's not criminal breach of contract. They have said
sorry, yes,
breach of contract.
it's a criminal breach of in the FIR. It is stated that there has been a breach of contract by the petitioner herein, and no criminal offense has been made out in the FIR. Stop. It is also submitted by the learned counsel that this is a purely civil case, and therefore the ingredients of section 316 clause 2 and 318 clause 2 of the BNS are not present in the instant case. It is therefore prayed that the impugned FIR and the subsequent investigation process may be quashed and set aside. Stop. Para. Issue notice returnable in 4 weeks. Learned Public Prosecutor Mr. V. Jamomi has accepted notice on behalf of the respondent number 1. Hence, no further notice, formal notice is called for. Stop. The learned counsel for the petitioner shall take steps for service on the respondent number 2 by speed post as well as usual process within 3 working days. Stop. Till the next returnable date, the the FIR dated 14/5/2025 and the ensuing investigation and the subsequent investigation therein shall remain suspended till the next returnable date. Stop. Least after 4 weeks.
Lordship,
Yes.
it is registered as GR 91 of 2025.
Already
Before that-
registered, na?
Yes, Your Lordship. I was arrested and.
Just, okay, just
bail
say
has been granted.
FIR dated such and such and the proceedings of GR 91 of 2025.
Yes, Your Lordship.
91 of 2025 shall remain suspended till the next returnable date. Least after 4 weeks.
All hearing, item number 17.
May it please Your Ladyship. Your Ladyship, kindly allow me to make a submission. Although my name is not there in Vagalatma, on behalf of Takakuchu, who is outstationed today due to urgencies. Your Ladyship.
No, without your name being there, can you submit?
Your Ladyship, if Your Ladyship allows.
I don't think that's proper, isn't it? Unless there's an authorization from the council.
Right.
Yes, please, Your Lordship.
Yes.
Otherwise, also, I had to talk with his senior. So he had some emergencies. I had to talk of it. The matter, it's a fixed matter. It has been fixed for 2-3 occasions. It's a fixed matter. Fixed
When
matter.
is he coming?
Ladyship, very much uncertain.
Told me that his junior will appear on his behalf.
No, you just sign in the Vakaladama, that's all.
Ladyship.
Yes. And we can take it up tomorrow also.
Ladyship. All right, Ladyship.
Tomorrow, is that okay? Oh, tomorrow is a holiday, day after. Day after.
Thursday. Day after tomorrow is division bench.
Oh, yes.
Thursday.
Thursday.
Yes, Your Ladyship.
And then you take permission from your senior and then you sign in the,
Yes,
in the
Lordship.
Vakalatama. Thursday is
Maybe Lordship, it is fixed on
9th.
April 20, because in between you have a Bihu festival.
Oh,
I have no objection, Your Ladyship.
wait. Tomorrow is 31st, isn't it? Then first, second you can appear, I'm sure. Thursday, that is before Bihu. Otherwise, this is an old case.
Maybe tomorrow, Lordship. I said
Tomorrow is
tomorrow.
holiday.
Holiday, yes.
Tomorrow is a holiday, and Wednesday is division
Because I
bench.
used to stay here in the hotel only, Lordship. That is the only issue.
Okay. So second also not possible.
Second also not possible, Lordship. Nine to the election. Election is also there.
Election is also
On
there.
9 there is election.
Yes, 9 is election.
No, whole week is there. 6 to 6, 7th is also there.
Lordship, maybe on 7.
7th. Okay. List on 7 4. 6 also. 6 yes. 6 4. You do the needful and then
Yes,
even if Taka is not there, we can take it up.
Nowadays, I used to come from the Lakhimpur only, Lordship. Because
Oh,
I have
you don't stay in
No,
Dimapur
Lordship,
also?
I have shifted my residence
Oh,
because of that. All right, Lordship, no problem.
but now only few cases are there. I
Yes,
think.
yes.
Hello.